The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by my colleagues, Justices Milkey and Henry. We are hearing argument this morning by video conference in light of the ongoing pandemic. And this morning we'll be hearing a single case. It's number 20-753, Commonwealth versus Nova. Each party will have 15 minutes, just as you would in our courtroom if we were doing this in person. There is no rebuttal. And with that, we will hear first from Attorney O'Reilly.
Good morning, Your Honors. Anne O'Reilly for the defendant, Paul Nova. The first issue I'd like to address is the possession issue. The defendant had no actual or constructive possession of the heroin that was found in the console. Mr. Nova was a passenger in a Ford that was driven by his once co-defendant, Dorvillis. Dorvillis had been charged, but the charges against him were dismissed. Officers found heroin in plastic bags in the passenger side cup holder on the console between the front seats. The Commonwealth's theory was that the defendant possessed actually and constructively the heroin that was found in the vehicle. The defendant's motion for required finding was denied, excuse me, but there was no evidence that the defendant possessed the heroin beyond a reasonable doubt under Lattimore. There was no evidence of actual possession, and for constructive possession, the Commonwealth had to prove knowledge, ability, and intention to exercise dominion and control, pardon me, under Ortega. So courts have held mere presence where drugs are discovered is not enough to support the inference of possession. There has to be a plus factor. Here, there are no plus factors. Nova did not own or rent the Ford. None of his personal effects were found in it. No other indicia of trafficking, such as baggies, scales, notes, or ledgers were found. There were 4 cell phones found, but there was no evidence.
Counsel, how do you address his trying to hide the heroin from the police officer with his hand?
Well, I would argue that was an ambiguous hand gesture. O'Brien testified that the defendant put his hand up to block his line of sight to the console. But really, Foley, who was the other officer on the other side of the car, testified he couldn't see inside the car. So
Sorry, but an ambiguous gesture has to be construed in the light most favorable to the Commonwealth, doesn't it? That's what the Lattimore standard is, isn't it?
Well, the light most favorable to the Commonwealth. However, I found no case law about consciousness of guilt regarding ambiguous hand gestures. Consciousness of guilt testimony.
That's not the question. Isn't were there these facts before? The question is, how are we to construe this? And the officer testified not only that the defendant attempted to hide the heroin with his hand, but that as the officer moved, as his head moved outside the car, the defendant moved his hand in such a way as to continuously block his line of sight to the cup holder containing the heroin. Now, I understand that maybe that's not what he did, or maybe he didn't do anything. I have no idea, but that's the testimony. And I guess I just don't see why we're not supposed to construe that in the light most favorable to the Commonwealth, as if, in fact, that's what the defendant did.
I argue that the hand gesture is ambiguous. There was no evidence he was reaching to grab the heroin. None of the officers testified that they saw him carry anything. And also the heroin could have belonged to Dorvillis, the driver. So
didn't the police though observe your client and a ride to nowhere in the other vehicle?
A meaningless ride? Yes, they did. But in terms of the hand gesture, I I argue also that it was reversible error for the judge or the defendant's objection to allow the Commonwealth to admit that as consciousness of guilt testimony.
You say it's consciousness of guilt. Isn't it a lot more? I mean, this is an action intended to hide contraband from the police. That seems to me a lot more than consciousness of guilt.
Well, there's no evidence that he tried to grab the plastic bag from the console. He didn't, he didn't take it and try to hide it under a seat or somewhere else. I argue that it's an ambiguous hand gesture, and even in the light most favorable to the Commonwealth, as I mentioned, Foley, the other officer, testified he could not see inside the vehicle. So for O'Brien to testify, it seems, that he could see perfectly inside the vehicle. And from the vantage point of the defendant, how could the defendant know exactly what the line of sight is of Officer O'Brien? So I believe that the evidence does not sustain that he was trying to hide the heroin. He could have been surprised. I mean, there's a lot of ways to interpret that hand gesture. And in terms of the consciousness of guilt testimony and instruction, these courts have held the most common forms of consciousness of guilt evidence include flight or hiding to avoid apprehension that are not open to interpretation about something that could have been something else. In Roberts, it was an attempted escape. In Stewart and Matos, a flight. In Jackson, a police chase and shootout. Here, the hand gesture.
If the defendant had, I know this is not this case, but if the defendant had just placed his hand, like if he'd had the heroin in his hand and he just placed his hand out of sight of the officer, like put it behind his back, admittedly not a good idea, but let's assume he had done that, could that be evidence of consciousness of guilt?
It could be evidence of consciousness of guilt. However, if he were holding it, Commonwealth wouldn't have to prove constructive possession because there would be actual possession. Here, the jury.
So let's assume it's something different. Like people have those little window shades on the side of their window. If he had just pulled the window shade down, would that be evidence of consciousness of guilt potentially?
It's a theoretical possibility. It could be because it's not ambiguous if there's the pulling of the shade down. Here, we don't know really from what O'Brien can see and not see. He testified that he saw a plastic bag in the center console, but how, in terms of the defendant, how can the defendant determine what O'Brien can see? He's looking inside, so the defendant puts his hands up. I believe O'Brien had his hand on his, holstered gun, which is, so he could have been afraid, he could be surprised, he could be shocked. The pulling down of a shade is a deliberate act that's not ambiguous. So I would argue that the hand gesture was ambiguous, and there's, it's a leap to consider that he was trying to hide the heroin. And
so the Commonwealth argues that the jury was specifically instructed that they were not required to draw an inference from the hand movement that the defendant was attempting to conceal drugs. So why is that not resolve your concern about the instruction and the gesture?
Well, I would, argue that the inflammatory nature of the interpretation of this ambiguous conduct outweighs its probative value. And really, that's the only quote unquote plus factor that's tying the defendant to the heroin. It's it's not his vehicle. His co-defendant, was charged. The charges were dismissed. There's no ledgers, there's no other indicia, there's no other plus factors.
What about the money held, first of all, the significant quantity of money, and then the fact that it was held in 3 different folds?
Yes, it was a significant amount. It was over $1,500 found in 3 separate, that was, on his person, but
Right.
that without more.
Factor, or perhaps 2 plus factors, isn't it?
Money found on his person.
Significant amount of money found in 3 different folds.
It doesn't necessarily connect him to the heroin. I mean, he was also charged with the cocaine that was found in DeVillis's socks. So,
Yes, but someone being a cocaine dealer might well be a plus factor for whether heroin found in a car right next to them is theirs. Well, maybe you should go on to your next argument.
I would argue that without more, it's insufficient. And in Bienvenue, the appeals court found that the co-defendant did constructively possess contraband found in a car, but the plus factors were that she owned the vehicle, her personal effects were found in the back, and she was close to it. But in any case, I would move on to my next argument regarding the closing argument. The prosecutor exceeded the scope of her closing argument by making statements during her argument that were not based on reasonable inferences from the evidence. Trial counsel objected. There were no curative instructions. Prejudicial error was created. In her closing, she stated, and these were objected to. She stated some other statements in her closing that were not objected to. These were objected to. Ladies and gentlemen, the case is as simple as the defendant's ringing flip phone that continuously rang shortly after 7:20 p.m. on that Friday night. So this defendant in a rental vehicle has his driver travel to his next destination to distribute 19.99 grams of heroin by using his blowing up flip phone. And finally, she stated, there's 4 cell phones in that car. Does it matter where they're located? No, there's 4 cell phones in that car. O'Brien did testify that there were 4 cell phones found in the vehicle. 1 was continuously ringing, but there was no evidence connecting them to the defendant. Trial counsel objected to the cell phone references and to it blowing up. Objection was denied. There were no curative instructions given.
Why isn't it a reasonable inference if the jury believes that it's his heroin, or even that he sold cocaine to the people in the car before, and that's what the money in his sock and pocket and other pocket and so on represents, drug deals? Why isn't it a reasonable inference that the phone that's ringing all the time of 4 is his, and that he's a drug dealer and that people are calling him to order drugs?
There's no evidence beyond a reasonable doubt that the cell phones.
Is it a reasonable inference for the prosecutor? Prosecutor can argue reasonable inferences from the evidence, and I'm trying to figure out why you say it's not a reasonable inference that the one that's ringing belongs to him. Obviously, it's not the only inference. It's not inescapable. Obviously, it could be the other guy's phone, or for that matter, it could be someone else's phone. But But if they believe, based on the car ride, the money in the pocket, and he wasn't convicted of the cocaine, but if they believed all that, why wouldn't it make perfect sense that the cell phone that rings and rings and rings is the drug dealer's cell phone, since that's something drug dealers' cell phones do?
Well, the prosecutor, there was no evidence connecting him to any of the cell phones. Because all 4 of the cell phones, it's a reasonable inference to believe that they belonged to the driver.
I thought they were on the passenger side, or am I misremembering that?
I don't believe there was any evidence about where they were located. Certainly, there was no evidence that, I don't believe there's any evidence that they were located near the defendant. And so that's, the prosecutor argued in the closing, does it matter where they're located? No. It does matter where they're located. The courts have found, close proximity is important at times. So here, they're in the car. There's another driver in the car who there's a driver in the car, so there's no evidence connecting them to the defendant specifically. And in Nordstrom, the court found that the right to argue inferences from the evidence does not include the right to lead the jury to improper inferences not based on the evidence. So I would argue the judge erred in overruling the defendant's objection and failing to give a curative instruction. This is a very close case. There were 2 jury questions concerning constructive possession. And, the jury was, having a difficult time finding that the defendant did have constructive possession. So just one, prosecutor was trying to tip the scale with her mischaracterizations, which were objected to. So. Well, I see my time is coming to a close. So regarding the rest of the issues, I will rest on my brief. Thank you, Your Honors.
Thank you very much. Very well argued. We have your brief for your other arguments as well. And we will hear next from Attorney Billingsley.
Thank you. Good morning, and may it please the court. Christine Billingsley on behalf of the Commonwealth. I'll start first with the sufficiency of the evidence argument that counsel began with. Here, there was sufficient evidence to prove beyond a reasonable doubt that the defendant possessed the heroin that he was convicted of trafficking. An inference of knowledge of the heroin can be inferred where the defendant was located in close proximity to where the heroin was located, just to his left in the passenger side cup holder, as well as the fact that the heroin was located in plain view. The defendant's ability to exercise dominion and control over the heroin was demonstrated by his affirmative action in attempting to conceal the heroin when he was confronted by Detective O'Brien. It was only after Detective O'Brien approached the side of the car door, yelled, "There it is, open the door," that Mr. Nova turned and faced Detective O'Brien, made eye contact with him, and only then raised his left hand in an attempt to conceal what was next to him.
So defense counsel argues that the gesture could have been ambiguous. The officer's moving his head and maybe the defendant is just trying to make sure the officer can continue to see his hands. What do you say to that?
I would argue that the hand gesture was not ambiguous at all. As previously stated, Mr. Nova's hand only went up after Detective O'Brien had made eye contact with him. I believe that there was 2 arguments put forward in defense counsel's brief that Mr. Nova may have been attempting to shield his eyes from a streetlight or potentially from Officer Foley's firearm, which was drawn on the other side of the motor vehicle. And I would suggest that there's no evidence in the record to support either of those claims. There were multiple officers who testified that it was light outside at the time of this encounter, and that would cancel out any argument that Mr. Nova was shielding his eyes from a streetlight. Moreover, the argument that he was potentially shielding himself from the firearm that was drawn by Officer Foley would have to fail, as Mr. Nova's hand only went up when he was confronted by Detective O'Brien and when he was only looking at Detective O'Brien. So the movement with his hand and Detective O'Brien's head, a reasonable inference could be drawn that his sole intention in having his hand up was to block Detective O'Brien's view of the heroin.
Can I ask you about the closing argument?
Yes.
There are 2 pieces of it that interest me. One is the defendant directed the driver to flee.
Yes.
Is there any evidence that the defendant directed the driver to flee?
There's no direct evidence that Mr. Nova directed Mr. Dorvillas to flee the scene. However,
or indirect evidence?
I think it would have been a reasonable inference for the jury based upon the evidence that they heard to draw an inference. I would first argue
that he said anything at all?
No, there's no indication that Mr. Nova was giving any direction to Mr. Dorvillas.
I don't understand where that inference would come from.
It would have been reasonable for the jury to infer that Mr. Nova was engaged in some drug dealing type behavior based upon the totality of the circumstances that were observed by the Quincy Drug Control Unit. So I think that it wouldn't have been a stretch in that argument that the prosecutor made that he was in possession of this heroin. In terms of the impact or effect that it may have had.
Yeah, I'm asking not about the possession. I'm asking about this statement in closing that he told the guy to drive away to get out of there.
that statement, it may have been better left unsaid. However, I would argue that that statement, viewed in the totality of the closing arguments, was collateral to the central issue of whether Mr. Nova was in possession of this heroin and was guilty of trafficking the heroin. And especially in light of the fact that this argument was not objected to by trial counsel, who was very clearly a zealous advocate for his client, there seems to be some inference that trial counsel didn't find that this statement was harmful or prejudicial to his client. So any effect, if any effect, was mitigated not only by the judge's instructions to the jury that closing arguments were not evidence, but also would have had a minimal effect on their decision-making in this matter.
Was it objected to?
It was not objected to.
And can I ask you about the statement? No one is saying the defendant should have hidden the heroin better, except the defense counsel.
Yes.
Did
So-
defense counsel say that the defendant was guilty but should have hidden the heroin better?
He did not say those exact words. Trial counsel in his closing arguments posed several hypotheticals to the jury, suggesting that if in fact the heroin was Mr. Nova's, he would have hidden it in a different manner, or he would have concealed it in a better fashion. He went on to argue that the Commonwealth theory—
If it was his. So the argument by defense counsel was, this is not my client's heroin. This hand business is not significant. Someone who wants to hide heroin doesn't hide it like that. They put it under the seat or in their sock or throw it in the back or stash it somewhere. They do something more with it. That's not saying that the defendant should have hidden it. It's saying the fact that he didn't hide it shows it isn't his. So then the prosecutor says to the jurors, defense counsel says he should have hidden it better. That's not our position. So what is the point of that sentence?
I think the argument viewed in its whole was rebutting the defendant's argument, or excuse me, trial counsel's argument, and the hypotheticals that were posed to the jury. And while those two specific lines that are now challenged on appeal may have been better left unsaid by the prosecutor, I think the argument viewed in its totality was an appropriate response to counsel's argument and arguing against the Commonwealth theory of the case.
It's appropriate to say to the jury, defense counsel says his client should have hidden the heroin better.
I think it was an appropriate argument to rebut counsel's theory in closing argument.
Isn't it
I don't-
mischaracterizing what the argument was?
I don't believe it was mischaracterizing the evidence throughout the
Not the
entire—
evidence, mischaracterizing defense counsel's argument.
I don't believe so. I don't believe so. Where trial counsel was arguing that it was if it was Mr. Nova's argument, he would have hidden it better. He would have concealed it better. I think it was appropriate for the prosecutor to rebut that argument and say, defense counsel's arguing this theory to you, and this is why. I'm not.
At the beginning of that paragraph, the prosecutor says, look, maybe he's not the brightest guy or whatever. And that part of the argument, if what it's saying is this, I agree, this is a stupid way to try to hide heroin. There's two police officers with guns outside the door of the car. They're going to be coming in a second. They're finding what's in the cup holder, and your little gesture with the hand is utterly useless. Okay, I get that. But then the prosecutor goes on to say, we're not saying he should have hidden it better. No one is saying that. That's not what this is about, I don't think. Well, except the defense counsel is saying that, is saying he should have hidden it better. Doesn't that create the impression that, I mean, I'm not sure what it does. Maybe it mocks defense counsel's argument, or maybe it implies that defense counsel really, let's face it, has to concede that this is his drugs. And the fact that he didn't hide them, you know, if you think he should have hidden it better, defense counsel, okay, well, he didn't, and now here he is. I'm not sure what the impact of that, I'm not sure what it's designed to mean, and I'm wondering what the impact of that is on the jurors.
I would argue that this was not an attempt to mock trial counsel's closing argument. It was an attempt to respond to his argument and the hypotheticals that he had been posing to the jury throughout his closing argument. To the extent that it had any impact on the jurors, I would argue that it was minimal at most. Again, this is a situation where trial counsel did not object to the statements made by the prosecutor in her closing arguments, which the court can infer that means that trial counsel found no problem, didn't find the statements to be problematic at the time, which I think, again, in light of counsel's zealous advocacy throughout the trial, is important to note. Again, the judge and his, both right after the jury was sworn in and after closing arguments and charging began, instructed the jury that closing arguments were not evidence and that they were to rely on their own memory of the evidence. And I think that those instructions mitigated any harm, or excuse me, any error, if there was any.
So I'd like to turn to the cell phones. So is it correct that all we know is that there were 4 cell phones in the motor vehicle and we have no idea where in the vehicle they were?
There was testimony from Detective O'Brien that the 4 cell phones were recovered from the passenger compartment of the car. No more information as to the specific location of the passenger compartment, but they were located in the passenger compartment.
But that doesn't mean they were on the passenger side of the car. It just means they were in the part of the car where people ride, right?
That could be a reasonable inference that the jury could have drawn. I can address, counsel argues that there was no connection between Mr. Nova and these 4 cell phones. Again, drawing back to his behavior and the behavior that was indicative of drug distribution, it wasn't an unreasonable inference for the jury to conclude that the phones could have been attributed to Mr. Nova in that situation, especially in light of the testimony from Detective Lieutenant Perchard and his experience with the drug distribution in Quincy and the South Shore.
So how can the jury conclude that the 4 phones are connected to the defendant?
Based upon Mr. Nova's behavior. So as previously stated, Mr. Nova was observed taking a meaningless ride around a block in the city of Quincy. He, a resident of Dorchester, took this meaningless ride with a resident from Hanson and I believe a resident of Rockland. After that meaningless ride had concluded and he had entered into the fusion and was subsequently confronted by Detective O'Brien, he was found to have 3 folds of money located in 2 diverse locations on his person, totaling over $1,500. He was seated next to 19.99 grams of heroin, individually packaged in amounts consistent with distribution, I believe quarter fingers and gram bags alike. The 4 cell phones could have been attributed to him based upon that information where his behavior was already indicative of drug distribution, where he had taken the meaningless ride, where the passenger of the Grand Prix was observed, found to be in possession of 4 bags of cocaine. All of that tied together could have led the jury to infer that the phones did belong to him and were being used in his drug distribution business. If there are no further questions, I'll rest on my brief.
Okay, thank you very much. Excellent argument by both of you. I think we understand both of your arguments. The case is submitted.
Thank you, Your Honors.